Hi, in this session, we are trying to understand how liquidation is carried out under insolvency and bankruptcy code. In the previous sessions, we have understood insolvency. I'll do a quick recap of what we have understood in the previous sessions. Firstly, about insolvency, just a quick recap from what we had done in the past. Number one, it's a comprehensive law aimed at resolving insolvency and bankruptcy both. This was introduced in the year 2016 and many cases have been resolved which are very difficult. NPAs have been resolved after the introduction of IBC that we know. It provides a time-bound process. We remember that there is 180 days of time within which the insolvency shall be resolved. Otherwise, with the permission of the adjudicating authority, the time can be extended by another 90 days. So overall, we have a 270 days time frame within which the insolvency shall be resolved under IBC. Then we know that this entire process is, focused on transparent, quick debt recovery and offers a structured framework in which we have a lot of professional bodies which are involved. It must be noted that introduction of IBC has significantly improved business environment in India. Just for your information, there is a ranking called as ease of doing business. 143 countries do business with each other, and out of these countries, whichever country makes life easy for the other countries, that country will be rated as number one in terms of ease of doing business. In the whole ranking, India stood at 128th rank before the introduction of IBC. But quickly after the introduction of IBC, India's ranks have jumped far ahead and now we are standing on 72nd position in terms of ease of doing business. So you know that one law called as IBC has phenomenally changed the position of business environment in India. Also, a quick understanding of the 5 pillars of IBC. First one is called as Insolvency and Bankruptcy Board of India, which is called the regulator, which will frame the regulations as to how the liquidation as well as insolvency should be carried out under IBC, and will also regulate other 3 professional bodies which I'm going to show you shortly. Insolvency professional agencies, for example, Institute of Chartered Accountants of India, Institute of Company Secretaries of India, and Institute of Cost and Management Accountants of India have their own insolvency and professional agencies in which the professional members are admitted if they are qualified as a insolvency professional. So this body will actually look into disciplinary aspects of the insolvency professionals and try to regulate them. This is one Section 8 company which is non-profit organization. Then insolvency professionals are individuals who are members of this institute who are responsible to conduct the insolvency resolution process as well as the liquidation process under IBC. Therefore, these professionals are very, very important pillars of this profession who will efficiently carry out the process, but who are monitored by insolvency and professional agency and also ultimately monitored by IBPI. Then there's a 4th pillar called as Information Utility Center, which provides information about the borrowers and the NPAs and the assets which are mortgaged under insolvency and bankruptcy code. So this is an important agency which is focused on giving information to the creditors about the borrower. And the last and the most important agency we all know is called as a adjudicatory authority. In other words, National Company Law Tribunal along with Debt Recovery Tribunal will act as adjudicatory authorities within the provisions of IBC. These 5 pillars together will hold the IBC stiffly and will carry out the process efficiently. Understanding about IBC, how IBC is structured, we have covered that in the past, but we have not gone into the overview of how this is structured, how many sections are there and how many chapters are there. IBC was introduced in 2016 with about 255 sections organized in 5 different parts. I'll just show you what are those 5 different parts. Part 1 is called as preliminary, which contains definitions and scope of the act, etc., which is the very basics of the act. There is nothing much in that except for definitions and understanding the scope and applicability of the act. But the second one is very important chapter which has a lot of important provisions. Primarily, it talks about insolvency resolution process, which we call as CIRP. It also talks about liquidation process, which comes after the failure of a corporate insolvency resolution process. So this is chapter 2, which comprises 7 chapters within. I will call it as part 2, contains 7 chapters, and this spans from section 4 to 77th section. After that begins Part 3, which is insolvency resolution for individuals and partnership firms, which starts at section 78 and ends at section 187, which comprises 7 chapters. The Part 4 deals with regulation of insolvency professionals, agencies and information utilities. The other 3 very important pillars come in Part 4, and their provisions are enshrined in 7 chapters spanning from section 188 to 233 sections. And the last and the other part, which is maybe not so important in terms of understanding the IBC, is the part 5, which deals with miscellaneous provisions spanning sections 224 to 255 of the Act, and 255 is the last section. Is IBC a very big law, or is it a small law? There are legislations in India which are spanning about 60-65 sections, and there are legislations in India which span like about 470 to 500 sections. But IBC only comprises 255 sections, though there are multiple chapters within each part, but the overall number of sections are only 255. Therefore, I will not call it as the biggest legislation. I will not call it as the smallest legislation, but this is a reasonable size which is comprehensively providing all about insolvency and bankruptcy at one place. Moving forward, we will understand key features of CIRP, which we have already completed while understanding the insolvency resolution process. How many of you are able to recall what we discussed in the past? When I talk about CIRP, Part 2 of Insolvency and Bankruptcy Code, providing for insolvency and bankruptcy and liquidation, what do you recall in your mind? Quickly try to remind yourself what you have studied. Okay, so let's go forward and understand what we have seen in the past. First one, we've understood section 7, 8, 9 and 10 that talk about how to make an application in case of an insolvency by a corporate debtor, right? The application can be either made by financial creditor or by the operational creditor, or lastly by the corporate debtor itself. This was section 7, 8, 9 and 10. Then admission of IRP, we have also seen under section 14 how the CIRP will be admitted by courts and what are the consequences of such admission. Publication, once the CIRP is admitted, RP is appointed or IRP is appointed, which is called as interim resolution professional. Such interim resolution professional will publish an advertisement in newspaper inviting claims from the creditors. Okay, so we begin here. We understand key features of CIRP. I've just now asked you to recall whatever you remember. I'm sure you made your attempt, but what we have studied in the past are the following few topics. Number one, how to make an application In case of an insolvency of a corporate debtor, Section 7, 8, 9 and 10 comprehensively provide as to who can make an application and how they should make application. It can be made by financial creditor or operational creditor or by the corporate debtor itself. Then how the CIRP application is admitted by the adjudicating authority, and after that there is also appointment of insolvency resolution professional. In this case we call him as interim resolution professional. Once interim resolution professional is appointed, he will make a publication inviting claims from various creditors of the corporate debtor. Then we verify the claims and the claims are admitted. After that, COC is constituted, which may comprise of financial creditors at large, and in case need be, we also have operational creditors, and finally we also have corporate debtor within the scenario. Information memorandum is prepared by the resolution professional on being advised by the COC after it is being constituted, and this information memorandum provides substantial information about the assets of the corporate debtor, about the business activities of the corporate debtor, and will actually attract various corporates towards acquisition of this corporate debtor which is currently insolvent. The whole purpose of information memorandum is to give them information so that they will actually try and bid for acquisition of this company. Later on, the insolvency resolution professional RP will also request for a proposal from each of these shortlisted corporate acquirers who are ready to buy this corporate debtor. Once the resolution plans are requested by the resolution professional, various parties which are called as resolution applicants who are willing to buy the corporate debtor will submit their resolution plans. Resolution plan will basically have those contents which are defined in section 30 and 31 of the Act, which tell you what amount of consideration they are willing to pay to acquire this corporate debtor. Once we receive all these resolution plans, we evaluate these plans and then decide which is the best plan. That plan will be presented by resolution professional to the COC, which is Committee of Creditors. Such COC will approve this resolution plan, and ultimately it is presented to the adjudicatory authority, which is no one but National Company Law Tribunal. Once the National Company Law Tribunal approves the resolution plan, it is all about now payment of money to the various creditors and then subsequently implementation of the entire resolution plan. My friends, this is what we have discussed in our previous sessions about insolvency. So I have made my attempt to summarize, recap all those provisions. From now, we move forward to understand the concept of liquidation and various other terms which are used interchangeably. Though they are used interchangeably, there can be distinction between two different words which are used here. I will try my best to explain you how these different terms work. What are we going to understand today in this 41st session is all about liquidation. Very, very important word under the Insolvency and Bankruptcy Code. Let's understand firstly two different words. I don't know how many of you observed this, but when you look at the title of the Insolvency and Bankruptcy Code, there are two distinct words that are used. On one side we have insolvency, on the other side we have bankruptcy. So what does that mean by these two words, and how different are they from each other? There are two schools which think of these terms. Firstly, somebody says insolvency is a scenario where a corporate debtor fails to repay its debts, whereas bankruptcy is a scenario where individuals and partnerships fail to repay their debts. So both are different in their views. This is one school of thought. But the other school of thought says that the word bankruptcy will begin at the scenario where insolvency resolution fails. I will try to explain you. Insolvency is a scenario where the debts are not being repaid by the corporate debtor because of a financial crisis. Now, to come out of this financial crisis, an application is made to adjudicating authority for CIRP. If CIRP is successful, then the company is revived and the business activity commences as usual. But where this process fails, what is the consequence? The consequence is called as bankruptcy scenario, where the assets and liabilities of the company will now be decided, disposed of, and finally a company will be totally dissolved. This process can be called as bankruptcy. So we are trying to understand these two words. Let's see how different they are. First one, insolvency refers to a situation where debts could not be repaid. That's why we are saying not solvent. Second point is, it may be resolved through the process of CIRP. So what we are trying to say is, just like a medical condition of fever or viral bacteria within the body of an individual, insolvency is a condition. Can this condition be treated? Yes, it can be treated if you put in a process called as CIRP. If this process is successful, then the corporate debtor will be revived, insolvency position will change, and the corporate debtor will run in good condition ever after. Now, is it always guaranteed that the CIRP will be successful? No, it may not be successful. Hence, there is a bankruptcy. Bankruptcy refers to a situation where insolvency cannot be resolved, and therefore, as a last resort, what we do is we liquidate the corporate debtor by selling its assets and repaying its liabilities. This process is called as liquidation, and the condition is called as bankruptcy. So what are we saying? Bankruptcy is a scenario. If you fall into that scenario, the next step is obviously liquidation. Now let's try and understand what is liquidation and how does that work within IBC. Mark these words which are actually underlined. Liquidation is nothing but a process during which assets of the company or of the individuals are sold and we collect money, which is called as sale proceeds. These sale proceeds are used to repay such creditors of the company who could not receive money till now. This is a very good step because the company cannot be revived. The creditors could not be repaid. As a last resort, we sold the assets of the company, we got some money, and that money we are using in repayment to the creditors. That's step one as part of liquidation. Step two that we need to understand is, it begins after the CIRP fails, or if there is no viable resolution plan approved, the liquidation will begin. Then we are going to sell the assets of the company. We distribute the sale proceeds to various creditors, and after that, if there is anything left over, that leftover proceeds we distribute to various shareholders of the company under the waterfall mechanism that we've already studied. And lastly, one point that I would like to say is, it is the last resort. Liquidation is not a fancy thing. I don't know how many of you relate to my example when I tell you that if you look at an individual whose health is deteriorating, at the first step we try to do a treatment by giving medications, pills, etc. After that, if it doesn't work, then we undergo a surgical procedure, which is medical intervention. After that, if the things do not improve, then maybe we try to put the person on artificial life machinery, and if that fails, where the person cannot be revived, then in a hopeless situation, we leave the person to the God's grace and pray that he dies peacefully. This is exactly what happens in case of a insolvency. First we try to revive. If it doesn't revive, then we put it under a liquidation process. We try to sell the assets of the company and then distribute the proceeds to the creditors. After that, we let the company die peacefully, which is the end stage of the liquidation, right? This happens when it is no longer viable to run this business. Again, there are two terms, liquidation and dissolution. This can be confusing if you do not understand. Those who are coming from a corporate law background or those who are coming from commerce background will know these two terms, but those who do not come from them, the two terms will be confusing. What is liquidation and what is dissolution? Because these are used frequently within the books, these are used frequently on the internet and amongst the professionals. So let's understand what these two words are and how different are they from each other. First one, as I repeatedly said again, liquidation is a process which includes many things: identifying the assets of the company, selling the assets of the company, receiving sale proceeds, paying them to the creditors, etc., etc. So this is a process which has 10-15 different kind of steps involved. But the last of this process ends with one event which is called as dissolution. So what is that dissolution? Dissolution refers to striking off the company's name from the register maintained by the registrar of companies. So now registrar's books or the register, there is no name of the company anymore. It is wiped out totally. This last step is called as dissolution. After that, there is no existence of the company anymore. But remember one thing, as long as the liquidation is in the process, the company continues to exist. You can see here on the fourth line that while the liquidation is on, company continues to exist. But once liquidation comes to an end, dissolution happens. That's the termination of the company's existence. So these are two words which are liquidation and dissolution. I'm sure now you could easily identify the difference between them. Now we try to also understand, when I am using the word liquidation, what is the law surrounding liquidation under IBC? Where are these provisions? Do I have to read anything more than IBC? Yes, that's what we are trying to understand. So in part 2, we said part 2 deals with insolvency and also bankruptcy and liquidation of the corporate persons. So in the same part 2 of IBC, chapter 3 specifically deals with liquidation under IBC. Talking about legal framework for liquidation under IBC, we just said part 2 of or chapter 3 of part 2 deals with liquidation of the corporate debtor, which are sections spanning 33 to 54 of the Act. And apart from that, we also have certain regulations framed by Insolvency and Bankruptcy Board of India in 2016, which we call them as IBBI, Liquidation Process Regulations 2016. So what is the legal background for liquidation under IBC? Which Act, which regulations, what sections, which part, which chapters deal with insolvency and liquidation? Right now, talking about liquidation, chapter 3 of part 2 of IBC deals with liquidation, and while sections 33 to 54 of the Act enshrines various provisions as to how liquidation should happen, and then these two, along with the regulations framed by IBBI, by the name IBBI Liquidation Process Regulations 2016 will provide a comprehensive legal framework for liquidation. Once you follow this, your liquidation can be completed as per the law. But only remember that in spite of having various provisions in the Act, and though you're complying with the regulations framed by IBBI, the entire process is overseen by adjudicatory authority to ensure transparency and efficiency of the entire process. As we spoke about liquidation under IBC, the next important concept is trying to understand, is there any similar concept like liquidation in any other law that deals with the corporate or corporate debtor? The moment I am saying corporate debtor, predominantly corporate debtors are all companies which are registered under either Companies Act 1956 or registered under Companies Act 2013. The moment I am using the word company, anything and everything about company is dealt in Companies Act 2013, including its liquidation. But only thing that you need to understand is when it comes to the concept of liquidation under the Companies Act 2013, we call it as winding up and not liquidation. So, though liquidation and winding up are very similar concepts, they are almost one and the same. They are dealt with in two different laws in two different ways. In Companies Act 2013, we have Chapter 20, White sections 270 to 365 deals with the winding up, and also supported by Companies Winding Up Rules 2020. A very interesting question. What is the difference between regulations and rules? In the previous slide, if I take you back, you are seeing here that there is IBBI Liquidation Process Regulations 2016. But in the next slide, as I am talking to you about Companies Act 2013, I am showing you Companies Winding Up Rules 2020. So most of us should naturally get this question as to what are rules, what are regulations, and what's the difference. For those who do not know, rules are generally framed by the central government or the state government under the law, and they form integral part of the enactment itself. But whereas regulations, like in the case of liquidation process regulations, are framed by regulator who is specifically entrusted with the job of overseeing a certain activity, like SEBI, IBBI, RBI, etc. will form regulations. As far as Companies Act is concerned, Chapter 20 and the rules made under this Act will deal with the winding up. But as far as liquidation is concerned under IBC, Part 2, Chapter 3 deals with liquidation, and we remember the sections, there are also regulations. Let's move forward and we understand there is one more important concept. Liquidation essentially happens after failure of a CIRP in our understanding. And hence, liquidation is a consequence of failure of CIRP in most of the cases. But can a company which is running well, healthy, and which has all financial health by itself, can it choose to shut down its business, liquidate itself? Yes, it can. If it chooses to liquidate itself, it is called as voluntary liquidation. You can see that word voluntary, which is very important. In the second point, I am showing you that a financially healthy, viable company which has never become insolvent can also be liquidated. If it chooses to get liquidated, such liquidation is called as voluntary liquidation. The beauty of the entire concept is both liquidation and voluntary liquidation form part of the Insolvency and Bankruptcy Code and not Companies Act 2013. And therefore, whether you are doing liquidation or whether you are doing a voluntary liquidation, you shall still follow the provisions of IBC, which are majoritarily the same for either voluntary liquidation or liquidation. What can be the reasons in that case for liquidation of a healthy company? I'll give you examples. If you have not been an insolvent company, if you have been healthy company, then why do you want to shut down your business? Reason can be somebody who's diversified substantially into other areas of business and have lost interest in the business, though it is profitable, may decide to wind up such company though it is profitable. Last and the most important one is a company is always created with a certain purpose in mind. If that purpose, if the objective is fulfilled, then we don't need to run the company anymore. Maybe the promoters and the shareholders decide to wind up or liquidate such company which is actually viable, which is actually healthy. If you decide, such liquidation is called as voluntary liquidation, and process more or less is same, but as far as regulations are concerned, IBBI has introduced a specific set of regulations only for voluntary liquidation. So those voluntary liquidations are different with the separate set of regulations. But as far as our subject matter is concerned, we are trying to understand liquidation, which is a consequence of failure of insolvency resolution, and hence our discussion will not span on voluntary liquidation. As I said, voluntary liquidation is governed by the IBBI Voluntary Liquidation Regulations 2017, whereas regular liquidation is dealt under Liquidation Process Regulations issued by IBBI. At this point of time, you might be wondering, can I ever understand how a liquidation of an insolvent company can happen? So what I always suggest is when you're studying a certain subject academically, especially law, there can be a lot of gray areas which are generally not thought of or understood. Hence, it is always important to relate what you have learned academically to what is being implemented practically elsewhere. So if you visit an IBBI website, there are enormous number of companies which have gone through CIRP, where CIRP is failed, and hence most of these companies are now pushed through liquidation. I'm just trying to give you some 4 or 5 examples which are going through liquidation. If your time permits, at your free time, please go ahead and study these cases practically and see how the law that you've studied is implemented practically in different scenarios, and then maybe you will have thousands of questions on implementation of liquidation under IBC. Okay, one of those companies is called as Jaipyar Power Corporation Private Limited. Other one is Madhav Ginning and Pressing Private Limited. Next company is Ambe Vaishno Steels Private Limited. Then we have Bajrang Infracon Private Limited. Lastly, we have Vantage Machine Tools Private Limited. These are the companies that are currently undergoing liquidation. I will request you to track these cases so that you can understand how it is being implemented. So now, at the end of session 41, I would like to summarize and conclude this session by saying what we have understood till now. Number one, we have understood two different words, what is insolvency and what is bankruptcy. Insolvency, we said, is when the company is not able to pay its debts. It can undergo a process called a CIRP, but when CIRP process fails, essentially it will go to bankruptcy, which is liquidation of the company. We've understood what we mean by liquidation. We said liquidation is nothing but selling the assets of the company, paying back the debts, and surplus which is remaining can be distributed to the shareholders. This process is called as liquidation. Then voluntary liquidation refers to a process where a healthy company which has never become insolvent liquidating itself under the provisions of IBC. It has a different set of regulations. It can be done, but under a different set of regulations, but the act commonly is same for liquidation or voluntary liquidation. Then we have understood the concept of winding up under Companies Act 2013. If it's a voluntary liquidation or liquidation of a insolvent company, it will come under IBC, but other modes of liquidation are called as winding up, and they fall within Companies Act 2013 under Chapter 20. Then we've also understood dissolution. Dissolution, we said, is last stage of the liquidation where company's name is removed from the register and its doors are shut forever. So friends, this is what we have learned under session 41, topic called as liquidation. In the next session, session 42, we will try and understand the legal provisions pertaining to the liquidation. Thank you.